Garden State GSCLE. 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 Garden State GSCLE.
What I'd like to do today is to provide you, in shorthand form, a way of getting yourself involved in the defense of an attorney ethics case and really kind of simplify the whole process, okay? Because when you come right down to it and you distill all the case law that's happened since 1947 and all the court rules and decisional law associated with this stuff, the defense of one of these cases actually comes down to answering 5 questions, all right? That's all. 5 questions, and you have to answer these 5 questions in every single attorney ethics case. Every single case, no matter what the underlying violation is going to implicate these 5 questions, okay? So what we'll do is we'll look at a couple of the administrative things that are associated with this. We'll talk about the 5 questions, the answers to the 5 questions, and when we get done, you guys are going to be ready to roll representing somebody on an attorney ethics case, okay? I want to start off by talking about the 3 foundational principles of disciplinary law in New Jersey. The citation of this quote here comes from a 1977 case, which is quoting a 1957 case. I have to tell you that this stuff goes back to 1947. I mean, this is something that is very well established in New Jersey law. It's probably been repeated 300 times as we go along. Take a look. The New Jersey attorney disciplinary system has one purpose: protecting the public. Its goal is to preserve the confidence of the public and the integrity and trustworthiness of lawyers in general, while preventing a reoccurrence of unethical behavior in the offending attorney. Now, when you write a brief or you stand up, I mean, this should always be your opening statement. Remind everybody what we're doing here. This has nothing to do with anything other than protecting the public. So any motivation, any sanction, anything you're dealing with that is not geared toward protecting the public is really irrelevant to the entire process. This should be the first line in your brief, the first thing you say in oral argument, reminding everybody to stay focused on what this is all about. When you say protecting the public, what are we protecting the public from? Essentially, it's protecting the public from attorneys who cannot comport their conduct to the requirements of law. Typically, those requirements of law are going to be encapsulated in the rules of professional conduct. So basically, this is what you have to say. Remind everybody that that's what this is about. And this really kind of dovetails into the second principle, foundational principle of discipline in New Jersey, that attorney discipline is not about punishment. It is not about punishing anyone. Punishment is something that's strictly within the province of the New Jersey criminal law. Attorney discipline is not about punishment. So one of the things I'm going to tell you as a practice pointer is this. In dealing with attorney discipline matters in New Jersey, excise from your vocabulary the word punishment. Never bring it up in terms of writing. Certainly never bring it up in oral argument, because it's not about punishment. They'll step all over you if you do that. What you should be doing is talking about things in terms of the quantum of discipline, the amount of discipline, the measure of discipline, the level of discipline, okay? Don't talk about punishment at all, because it just has nothing to do with anything. This is not about punishing anybody. Now, you can use this tactically, though, to your advantage in one limited instance. If your adversary is proposing a level of discipline that is completely disproportionate to what your guy did, then it's time to talk about punishment, because what you're going to say is, look, this system is about protecting the public. It's not about punishment. But what you've proposed here has nothing to do with that. It is punitive. For example, let's say your guy's practicing law, he's ineligible because he didn't pay his client security fund stuff, okay? He didn't get the letter or something of that nature. So he's out there practicing and he gets caught, and they want to suspend him for 2 years, okay? Well, that is something that's so utterly disproportionate to the gravity of what he did as an ethics violation that doing that has nothing to do with discipline at all. It's punitive in nature. That's the only time you would bring up punishment, because punishment cannot and should not be any part of this at all. The third and final foundational principle of attorney discipline is the following. This is a quotation of a fairly recent case in Witherspoon. We have rarely established bright-line rules that will govern disciplinary infractions, including serious matters involving criminal offenses. As a result, all disciplinary decisions are deemed to be fact-sensitive. The key word here is the word rarely. What they're talking about here are the establishment of bright line disciplinary rules, which basically mean the following. We will discipline you invariably based upon your act, what you did, okay? Once the act is proven, you're going to receive a particular level of discipline. And it doesn't matter what the mitigating factors are. It doesn't matter what the aggravating factors are. There is no defense you can raise that will give you any level of discipline less than X. It's going to be X on every single occasion. Now, I've categorized the times where there are fixed and immutable levels of discipline to be imposed. I want to talk about it for a second. I'm going to do this, though, with a little bit of a caveat because the law has changed significantly within the last 12 days. There was a significant Supreme Court decision which really changed everybody's outlook on the law. So we'll talk about that momentarily. The first rule that we're talking about dates back to 1979, the doctrine set forth by the New Jersey Supreme Court in Ray Wilson. Wilson was the first decision written by the late Chief Justice Will Lentz in his stewardship of the Supreme Court beginning in 1979, and attorney discipline was something that was just particularly important to him personally. In fact, the disciplinary system that we have to this day is very much a product of his vision. It's a legacy that he has left us over the years. So just both administratively as well as substantively, the disciplinary system we have today, for better or worse, is his system. It was he, for example, in 1984 who mandated that New Jersey attorneys would now follow the rules of professional conduct promulgated by the ABA. It was also he in 1984 that created and mandated, really created out of whole air, the Office of Attorney Ethics. It didn't exist as an administrative body prior to that era. And of course, a tremendous amount of the case law he wrote because he had a particular interest in this field. Wilson involves the taking of client funds by attorneys when it's done in a knowing fashion without the permission of the client. That is a violation of the law that had been treated very, very unpredictably by the Supreme Court in the years prior to 1979. Many times the attorneys were disbarred as a result of that. There was criminal prosecutions associated with it. But I would say that probably only 50% of the time that resulted in disbarments. The other times it resulted in all varying degrees of discipline, sometimes suspensions, sometimes less than suspensions. And the key factor in all these non-disbarment cases dealt with extraneous issues such as, well, he really needed the money because it was an emergency, or he replaced the money and nobody got hurt, or he took the money and put it back before anybody noticed, or he paid it back and everybody was made whole again, or he paid most of it back, or he's going to pay it back. He had a gambling problem, he had a drug problem, he had depression. Or sometimes, this is the only time he's been in trouble in 35 years of practice, he's the dean of the bar. All these miscellaneous things were utilized as mitigating factors in order to avoid disbarment. It was a desire of the Chief Justice and the other justices back in 1979 to eliminate all of this, 100%. And the idea behind it was to say, look, we don't care what your excuse is. We don't care what the reason was. If you do the following, you're going to be disbarred. A, take money from your trust account. B, that belongs to a client. C, without your client's permission. And D, do it knowingly. If those four issues are proved by clear and convincing evidence, you're going to be disbarred, and you'll be disbarred in every single case, irrespective of what the facts are with regard to any mitigating factors. There are no mitigating factors. There is no attorney that can save you. There is no exception to this rule. With a very unfortunate turn of phrase, the Chief Justice describes this as something that will be almost invariable. Now, I have to tell you, something can be either invariable or it's not. There's no such thing as something that's almost invariable, okay? But what I want to tell you is that since 1979, it has been invariable. And we're approaching about 500 attorneys who have either been disbarred directly as a result of action from the Supreme Court for these types of misappropriations, or alternatively, they've just consented to disbarment because they can't successfully defend themselves in this type of case, all right?
Another thing, I am incompetent.
I want to tell you a little story, and I don't think you'll mind me talking at a school about this. I was sitting in the Supreme Court one day getting ready to argue a disciplinary case, which, by the way, is nothing to be proud of, okay? I was just there. And they had a case in front of me. The attorney's name was Tsai, T-S-A-I. There's a very, very capable, wonderful attorney named Jeff Advocate from Passaic County. Who's Passaic County, guys? You're over here. I thought I saw you. You guys know Jeff, right? You know Jeff, right? Jeff's good people. he had a tough case. His client is running basically a revolving charge card out of his trust account where he would take money, spend it, replace it, a couple weeks later take more, spend it, replace it. And nobody ever lost any money because he kept replacing it, but he got caught in the random audit program. They found out about it, okay? So Jeff is up before the Supreme Court and making a pitch to try to save the guy's license and get him some sanction other than disbarment. And I'm watching the argument go. It's just a completely routine argument with Jeff doing his best. And the Chief Justice, who, by the way, is the sweetest, nicest gentleman you'll ever meet, was very, very courteous. And he wants to make sure that he gets every single syllable out that he wants to say. Because I think the Chief saw out of the corner of his eye that Justice Rivera-Soto wanted to kind of get into the mix here. So when Jeff had made his pitch, they turned to Justice Rivera-Soto, who's really one of these cut-to-the-chase kind of guys. And he said, Counselor, let me ask you just a couple questions, right? Did your guy take the money? Well, yes, Your Honor, he did. Okay. And did he have his client's permission when he took it? Well, no, Your Honor. No, he technically didn't. I said, okay. And did he do this knowingly? And Jeff thought about it. He said, well, yeah, I guess the evidence does suggest he did it knowingly. And Justice Rivera-Soto says, well, you understand that implicates the Wilson doctrine, and when we're dealing about Wilson, if it's a knowing misappropriation, our hands are tied.
But he always replenished it to cause no problem. And that's why I think, on one hand, severe sanctions are necessary. You can never close your eyes to actions like this, ever. But in this particular case, I respectfully would ask you to punish him in a way that's short of disbarment.
Any questions? Mr. Advocate?
Just with my client, his right to, I'm sorry.
Sorry.
Yes,
are you done with your preliminary statement?
Yes, sir, unless you have questions, of course.
Your client admits that he misappropriated monies out of his trust account?
Yes, misappropriated is our word, but yes.
Okay, and he also admits that he did so knowingly?
Your client, I want to look at your client as your client shaking his head no.
No, I know that, but he and I both feel that way, but I wanted to answer in a legally significant way.
And the only reason of the Wilson doctrine is
that's why I'm asking.
Yeah.
Because if it's knowing misappropriation, our hands are tied.
Now, when Justice Rivera-Soto said that, I was thinking to myself, what's he talking about? Your hands are tied. You're the New Jersey Supreme Court. You can do anything you want. You can untie your hands, okay? This is your rule. And it just bothered me, So I thought about it, and I figured out what he was talking about a couple days later. What he was saying is that the rule in Ray Wilson is so pervasive and so well entrenched that it has become institutionalized. It is as much a part of the New Jersey Supreme Court as the lectern and the benches that those justices sit on. What he was saying is that no individual justice or groups of justices is ever going to change this or even try to change it. It's just going to be an immutable law in our state that everybody's going to follow. I had the occasion to speak to Justice Rivera-Soto last night. He's going to be teaching here today, later this morning. And I said to him, Mr. Justice, I reminded him, I said, there's no reason you would have occasion to remember this quote or even the case, but this is what happened. And I tell people when I teach about this, about the immutable principles in Wilson, and he agreed with me that it is institutionalized. And he said, we had a case where the attorney took the money to pay for cancer treatments for his 9-year-old daughter who was dying, and we disbarred him. He said, when that happened, then we knew that the game is over, okay? This is the way it's going to be. So what does this mean for you as attorneys who get involved in these types of cases? Well, a couple things. Number one, when you're analyzing the case, you've got to make sure that your adversary is going to be able to prove each of the elements by clear and convincing evidence. Clear and convincing evidence is the level of proof that you're dealing with in these types of cases. And it makes a big difference. I mean, remember, one of the elements here is that it's a knowing misappropriation. If it's knowing, you get disbarred. If it's something other than knowing, you don't. I mean, that's really what it comes down to. So there's sometimes a very fine line between an attorney who acts recklessly or negligently in terms of his taking money out of his trust account, as opposed to somebody who does it knowingly. Many times that's what these cases are about, and you do your best, as you would in any other case, and advocate on behalf of your client. But I have to tell you, if you get a case where they've got your client, they've got him cold, they've got all the proofs that they need, you can't help your client. You just can't. And you have to tell your client fairly early on, look, the case is indefensible. There is no attorney who can get a different result from you. No level of advocacy on my part can change the outcome of this case. There's just no mitigating factor that I can present to the court that's going to make any difference. At the end of the day, they're going to wind up disbarring you. You have a choice under the circumstances. You can consent to disbarment. That'll end this matter quickly. You'll save yourself the emotional anguish and the money you're paying for legal fees. The case will be over, and you can start moving on to the next part of your professional life. And of course, then you have some attorneys, though, they want to fight it out to the very, very end. And these are sad cases because the results are inevitable, but you have to do what your client says. But I think you owe it to your client under those circumstances to tell them, nobody can help you. I can't help you, neither can anybody else, because this is an immutable rule of New Jersey attorney discipline. Okay? Now, Wilson was expanded in 1985. The Hollendiner case takes Wilson and expands it to a second type of financial transaction, and that is attorneys who are holding escrow funds. Okay, you have money you're holding on behalf of a client as well as other stakeholders in the escrow. The proposition in Hollendiner is that an attorney who takes money out of an escrow account in the absence of permission from all the stakeholders is going to be subject to disbarment. Now, what they did in Anton's case, he had money he was holding on behalf of several people in a real estate deal. He went to his client and asked if he could take his legal fee ahead of time from the escrow so that he could buy a car. And his client said, fine. The problem is he didn't check with any other stakeholders in the escrow, and they were angry about it. So the Supreme Court, because they were making a new rule of the disciplinary law, they made it prospective. They suspended him for a couple of years, but said from this point on we are going to invoke our immutable rule in N. Ray Wilson in all of these types of cases. Now, I want to talk for a couple seconds about the change in the law. You guys might have read the Sigmund case that was published on December the 18th. It is an extremely change, and let me just go through it real fast. In 1993, the Supreme Court published its decision, per curiam decision, in Ray Siegel. Siegel involved an attorney who had been doing two things that he shouldn't be doing. Number one, diverting fees that had been paid into the firm, and number two, diverting expenses in the sense that he'd been submitting phony expense vouchers, all right? And I have to tell you, the court just gave this guy very short shrift. They were not impressed by him at all. They didn't devote a lot of attention to the case. This was just a clear, flat-out disbarment case from the beginning as far as they were concerned. They were outraged by his behavior, this breach of trust that he had demonstrated with the people in his law firm. They cited Wilson and some other cases to demonstrate that disbarment was an appropriate case, but they never really came right out and said that this is a Wilson case. It just cited Wilson and indicated that generally disbarment would be the appropriate remedy in this type of case, generally being the relative word here, for which you'll see in a moment. So that was the end of it, and away he goes, and that's the precedent that's established. 5 years later, a case comes out called In Re Greenberg, Joel Greenberg. And Greenberg had on its face some similar facts. It involved an attorney who was, again, diverting legal fees into his own pocket, submitting phony expense vouchers. He had a lot of other things going for him that were not present in the Siegel case. He was in a dispute with his partners and took the money under a claim of right, saying that he was entitled to it because he had been basically cheated by his firm. He also had a significant psychiatric testimony that he was able to put forward, saying that he was suffering from depression and used bad judgment because of that, and went through therapy and things of that nature. So he made a very strong case that this was an aberrational conduct. It actually came about because he was so racked with guilt that he went to his rabbi and confessed, and his rabbi said, well, just go tell your partners, they'll be very understanding. Wrong answer. They were not understanding. Oh, they went to the cops. Okay, that's how understanding they were. This is such an unusual case because for quite a number of reasons. The first of which is that this respondent put on a furious defense. I mean, it's one of the best defenses you could ever see. Just wonderful advocacy and great expert witnesses and fact witnesses. He really just put on a great defense. So much so that although there was 5 justices voted to disbar him, based upon the precedent set in Siegel, he had a very strong impassioned dissent written in the case, highly unusual in an attorney disciplinary case, by Justices Stein and O'Hearn, saying this is not appropriate, it's not necessary, these are not Wilson-type cases, it does not mandate disbarment in every single case, okay? Just as a little coda to this, Mr. Greenberg, there were 2 really kind of unusual things about his case. The first was when the Office of Attorney Ethics went to the Supreme Court to temporarily suspend him from practice pending his case being resolved, which was fine. They ordered his suspension, but he was such a player in Atlantic County. His claim to fame was medical malpractice defense. And the insurance companies who had entrusted him with all these files, they got millions and millions of dollars at stake based on this guy's expertise. There had to be an orderly transfer of these files to new counsel. They let him remain on as a paralegal working for these new counsel that were going to come in to take over. And normally if you're suspended, you can't have anything to do with the practice of law. The second unusual thing, and I think this was largely as a result of the dissents filed by Justices Stein and O'Hearn, is he waited 5 years, went over to Pennsylvania, took the Pennsylvania bar exam, and after passing the bar exam, made a formal admission to be admitted to the Pennsylvania bar. Again, with a disbarment in your background, that's never going to happen. But the Pennsylvania Supreme Court decided they would make an exception in this case, I think largely on the basis of, A, the dissent written by Justices Stein and O'Hearn, and also, B, this court said, listen, if this had happened in Pennsylvania, even if we had disbarred the guy, the likelihood, given this record, is we would have readmitted him to our bar after the period of 5 years. So the way he went, and as far as I know, he's still practicing law in Philadelphia to this day. Very, very unusual case, but it resonates all these years later, as recently as December the 18th of this year. What happened on December the 18th of this year was the publication of the Sigmund case, and it's extremely significant because it really kind of reorients everybody's ideas about whether or not the Wilson case applies in those instances where there are the taking of fees and expenses improperly by attorneys, especially when it's done under a claim of right. The respondent in the Sigmund case, practicing in Pennsylvania, subject to Pennsylvania discipline, again, very similar story, taking money, taking fees, taking expenses, doing it under a claim of right, feeling that he had been ripped off by his own law firm and cheated out of fees and commissions to which he was entitled. That had some legs to it because he actually wound up taking his firm to arbitration and he got a $123,000 award in arbitration for back legal fees. But nonetheless, it's still stealing no matter how you cut it. And the Pennsylvania Supreme Court found that he had acted unethically, and they ordered a suspension of him for 30 months. Now, typically when you have a suspension, or any type of discipline that's imposed in another jurisdiction, it'll come over to New Jersey, and New Jersey will move for reciprocal jurisdiction. Typically, you'll get the same discipline that you got in another jurisdiction. But in New Jersey, this particular act would result in disbarment based upon the precedents in Siegel and in Greenberg. But this guy went in there, and he just knew all the nuances to argue and was able to persuade our Supreme Court that disbarment is not necessary in every single one of these cases. They are fact sensitive, and they will listen to mitigating factors and make those determinations on a case-by-case basis. There is no automatic disbarment rule for this type of case. So to the extent that we believed in the past that Siegel and Greenberg would result in Wilson-type violations every single time, that is not the law anymore. We were all wrong, starting with the Office of Attorney Ethics. And by the way, when you read the case law, I thought the Office of Attorney Ethics was spot on. I mean, I never would have parsed these cases to think that there was any possibility you could get anything other than a disbarment in these cases. But when it's a flat-out Wilson case or a Holland-Donner case, those are more rare, there's nothing you're going to be able to do for your client. Now, a couple of additional things where the level of discipline will be automatic in every case, you're not going to be able to help. One of them is bribery of a public official. Another case from the last month or so, Camerano. This is a guy who was the mayor of Hoboken in Hudson County and was involved in some type of bribery conspiracy issue while he was a public official. The Supreme Court in his case announced the rule of law that they will disbar attorneys who are involved in bribery of public officials, okay? Now, I have to tell you, this is nothing new at all. Every single case involving the bribery of a public official involving an attorney has always resulted in disbarment. There has never been anything other than disbarment in these cases. They disbar the attorneys when they're convicted at trial. They disbar the attorneys when they're acquitted at trial. It doesn't matter, okay? Every single instance of bribery of a public official has always wound up with resulting in a disbarment. They're just making official that for the future, there's nothing that you can do to prevent this. Now, as attorneys, what you've got to do, if you have a client who's jammed up with some type of mess criminally, and he's going to plead the case out, if you have any leverage at all in the plea bargaining process, you haven't pleaded guilty to theft or official misconduct or something like that, stay away from pleading your client guilty to bribery, because the bribery is going to result in the disbarment. You may be able to plead guilty to other things that will not implicate this rule that the court announced in the Camerano. Last thing that, again, this is a very recent case from this year, is the Cohen case. This is really a hybrid type of disciplinary matter. It deals with kiddie porn. And I think it came about as a result of a recognition by the court that they had been very, very inconsistent in the way they treated kiddie porn cases. Prior to the Cohen case, what they were doing essentially is anybody who was prosecuted federally for kiddie porn cases was disbarred. Anybody who was prosecuted locally by the Attorney General or by the county prosecutor's office, nothing happened to them. They get PTI, they get probation, and they'll get a 6-month suspension of their license to practice. So the determining factor in a kiddie porn case was who's knocking on your door at 6 o'clock in the morning. If it's the FBI, you're going to get disbarred. If it's the county prosecutor's office or the state police, nothing's going to happen to you. You're going to get a 6-month suspension, all right? I think the court, in recognition of this disparity that had kind of grown up over the years, used the Cohen's case to announce a new rule of law, which is essentially going to be, you're involved in a kiddie porn case, there's a high likelihood you're going to wind up being disbarred. Since they announced a new rule of law, they gave Neil Cohen an indeterminate suspension. The court says this is the first time they've used the indeterminate suspension. An indeterminate suspension is a suspension that goes for a minimum of 5 years, after which you could start making an application to be readmitted. This is something that's preserved for people who are on the cusp of disbarment. But again, something that's been rarely used. It's been around probably for 15 or 20 years, and the court says it's the first time they've ever used it. It's New Jersey's response to the harshness of our disbarment rule. In New Jersey, once you're disbarred, there is no mechanism for ever practicing law again, okay? I mean, we don't have any procedure that would allow you to ever be admitted to practice in New Jersey, and it's highly unlikely that if you're disbarred here that any other jurisdiction is going to admit you. But New Jersey is in a very tiny minority of states that has that rule. There's only 3 other states that do that. They are Ohio, Indiana, and Oregon. And by the way, now that I think about it, Oregon is the only other state where you can't pump your own gas. There's a law review article here. I just got to figure out what the hook is between the two of them. 46, I'm serious. There's something, you know, I read some op-ed piece for the Law Journal. There are 46 states in the United States, though, that have a mechanism for taking disbarred attorneys. They wait typically 5 years, and then they can make an application for readmission. Doesn't mean they're going to get readmitted, but they can make the application and demonstrate that they've taken the necessary steps to rehabilitate themselves. We don't have that in New Jersey. So the court basically created this indeterminate suspension as kind of a stopgap measure for people who are just, again, who really are on the cusp of disbarment, they said. I hope they use it more in the future because they had not used it prior to this date. Now, there are a couple of lesser included things that I want you to know about, and one of them deals with domestic violence. All of you who are practitioners out there know that anybody, and I mean anybody, can have a bad day and get jammed up with some type of domestic violence mess, all right? It can just happen. And if a colleague comes to you who has a domestic violence situation, you've got to know what the implications are in terms of attorney discipline. Remember, the rules of professional conduct, they apply both in your private and in your professional lives. This is a typical example of how the RPCs will come back and kind of affect you in your personal life. The discipline in domestic violence cases is limited to those situations where there has been a conviction, all right? And the case law says conviction. So if somebody has a TRO or an FRO, that's not going to implicate anything. These are civil-type cases. It's only when your client starts getting convicted of stuff, either in Superior Court or Municipal Court, that you wind up having issues related to attorney discipline. The 2 cases, Principato and I'm not sure how he pronounced his name. I say Majid, but I think that's mispronouncing his name. Stand for the proposition. They're companion cases published on the same day. The court creating a rule of law that attorneys who are convicted of acts of domestic violence will be subject to a 3-month suspension minimal, okay? Now, it's not a particularly neither one of these decisions is particularly well written, because when you stop to think about it, both the Principato and Majid cases involved attacks of one human being on another. In this case, men attacking women physically, all right? And I think they both wound up being convicted of assault of conduct, simple assault, something like that. Each of them was reprimanded because the court was creating a new rule of disciplinary law and they wanted to apply it prospectively. The only time that I know of in the published case law that they've imposed it is in the Margrabia case, where he received a 3-month suspension for an act of domestic violence. However, you guys know that there's a whole bunch of ways you can commit acts of domestic violence that have nothing to do with assaultive conduct. If you think of some of the predicate acts of domestic violence, you've got criminal mischief and criminal trespass, criminal restraint, harassment. AA. What's my favorite domestic violence offense? Lewdness. That's right. So this doesn't involve any physical touching with anybody, okay? So that being the case, what you'd have to argue if you have a client who has a domestic violence situation, there's been a conviction, if it's something other than assaultive conduct, your argument's going to be, listen, it's an act of domestic violence, yes, but both of these cases were really aimed at preventing physical harm from one human being to another. There was no physical harm here. It involves some other type of domestic violence where a human being was not endangered. And then you ask for a level of discipline that's different than the suspension that they would order in these other cases. Everybody got that? Now, I point these things out to you because these are situations where the outcome is pretty much written in stone and you're not going to be able to come up with any mitigating factors, especially in Wilson cases, Holland-Donner cases, and to a certain extent in the kiddie porn cases, certainly in the bribery of public official cases. Nothing's going to save your client. You've got to plead guilty to something else. Now let's move into the 5 questions we talked about earlier on, and they stem from, again, the Witherspoon decision back from 2008. Let's take a look at it. This comes out of Witherspoon. Our system of discipline, as a result, includes few bright line rules, okay, which we just saw what those rules were, because few are indeed the acts for which one sanction will be invariably appropriate. When they use the word invariable, they're talking about Wilson here, okay. Considering how best to protect the public, which is the goal of attorney discipline, from a particular attorney ordinarily, means outside the scope of Wilson, involves considering the ethical lapses both in comparison to our relevant disciplinary precedents and in the context of the attorney's history rather than merely identifying the attorney's specific unethical act. Again, when you're dealing with Wilson cases, you identify the act and the discipline flows from the act. Nothing else matters. Our evaluation of the appropriate quantum of discipline, therefore, is necessarily fact-sensitive. This one paragraph really sets forth the 5 questions that you have to answer in every single disciplinary case. Let's get into the questions, all right? Write these down. This is how you structure your case, and you've got to answer all 5 of them in every single contested case. Here we go. What are the facts? What happened here? Okay? Now remember that the disciplinary system is based upon the rules of professional conduct. It doesn't matter whether the RPC violation took place in your personal life or your professional life, as we said a moment ago. You've got to look at what happened. These RPCs are like statutes. They have elements associated with them, and you have to look and see whether or not your adversary is going to be able to prove each individual element by clear and convincing evidence. As a practice pointer, you've got to really harp on this level of proof of clear and convincing evidence. The definition of clear and convincing evidence appears in the case law, in re Seaman, and you have the citation here. In re Seaman essentially defines clear and convincing evidence as evidence that produces in the mind of the fact finder a clear conviction as to the truth of the matter that's being asserted. It's evidence that's so clear, direct, weighty, and convincing as to enable the fact finder to come to a clear conviction without hesitancy of the precise facts at issue. Now, if you're arguing a case where you're in a fact fight, let's say it's a Wilson case, and you're arguing that you're saying the taking was done recklessly or negligently, your adversary is saying it was done knowingly. If you're in a fact fight, you've got to be standing up and yelling and jumping up and down about this definition of clear and convincing evidence. Don't rely on whoever the fact finder is to what their opinion about what clear and convincing evidence is. Their personal predilections or their beliefs about what that level of proof is are irrelevant. You got to read them what the law is. If you're trying a case on a district level, for example, you may have 2 attorneys and a layperson who are going to be making the factual findings and the conclusions of law and the recommendation of discipline. If you're in a fight over a fact, you got to be pounding away at the precise definition of what clear and convincing evidence is. I would even do it if the Supreme Court appointed a special master to be the fact finder in your case. Let everybody be reading from the same script. Give them a copy of it. Put it in your brief. Say it in your opening statement. Say it in your closing statement. Keep pounding away on this definition when you're in a fact fight, because it's a pretty high standard to meet. And when the whole case hinges on the outcome of one element of an RPC, it's very important that you do that. So what are the facts of the case? What physically happened, okay? What are the actual facts that will justify proof by clear and convincing evidence of every single element of whatever RPC or RPCs are in play? Number two, and this one is a little bit complicated. How have these cases been adjudicated in the past through the Supreme Court precedent or through the Disciplinary Review Board? The New Jersey Supreme Court, in its early era, wrote disciplinary decisions all the time. I'm just constantly coming out with disciplinary decisions and build up a huge body of case law. Those cases are particularly important from 1984 on, because 1984 is when the code went into effect, and we started having these types of interpretations of the RPCs in New Jersey. The problem is that around 1993, 94, the court's written opinions began to dwindle tremendously, and instead they relied upon the Disciplinary Review Board to do all the writing for them. Now, the DRB is kind of an intermediate appellate court. They do de novo reviews of the disciplinary findings of the District Ethics Committee. They'll make de novo findings of fact, de novo conclusions of law, and make their own recommendation as to what the level of discipline should be. They pass it on to the Supreme Court, and 98.5% of the time, the court will adopt the DRB's recommendation. As a matter of fact, the court really doesn't want anybody coming up and asking for appeals from the DRB. They grant the applications for a review very, very rarely. You'd have to have something really wacky going on with the DRB's opinion for the court to take it. The only time you're entitled to a hearing as of right before the New Jersey Supreme Court in a disciplinary matter is when the DRB has recommended that you be disbarred. Then you get a hearing of right. But other than that, the likelihood of the Supreme Court adopting the disciplinary recommendation of the DRB is like 98%. So you got to take it very seriously when you argue these cases before the DRB. So these days, it is extremely rare for the Supreme Court to write a disciplinary decision. We've had 3 this year. We've talked about all 3 of them: the Camaroso case, Cohen's case, and the Sigmund case from December the 18th. That's been it for the year. Typically, the Supreme Court will only publish a disciplinary decision if there's they want to announce a new rule of law, or there's some big public debate about a particular issue or a particular attorney. Very, very unusual. The lion's share of all the law is coming from the Disciplinary Review Board. So what you have to do is, your starting point is, you go back and say, okay, my guy did X, Y, Z. It implicates these 3 RPCs, and these are the other factors in the case. You go back and see, how has the Supreme Court treated these types of cases in the past? You have to understand that why the prior history, or the prior way they've treated it, is so important is because the court wants the entire system to be both consistent and predictable. The last thing they want is something that's chaotic, where you can't predict what's going to happen to you. They want you to be able to predict where your discipline is going to fall within a particular range, given the facts of your case, okay? So you should be able to go back and look at the prior Supreme Court cases and see how people similarly situated to your client have been. Now, when you read the DRB decisions, and we're going to take a look at one in a couple seconds, you'll see many citations to New Jersey cases, all right? But there's a trick associated with this. Let's say you're reading it over and they say, as was held in Re Schmo, and they'll have a citation, 207 New Jersey, page 62, all right? 2009 decision. If you go to look up In Re Schmo in the New Jersey reports, it's nothing. It's just a disciplinary decision. It's just an order of discipline. It'll have the RPCs that were violated, and it'll have what the discipline was. That's it. There's no facts, there's no law, there's no reasoning, there's no nothing. It's just a disciplinary order. So what you've got to do is you've got to go back and find In Re Schmo that the Disciplinary Review Board wrote and read their opinion, okay? Because it's really their opinion that counts, not what the Supreme Court said, because the Supreme Court really never said anything. The problem is that the DRB's decisions aren't published anywhere. They're just in cyberspace, basically. They exist in PDF format on the Rutgers University Camden Law School Library website. Now, you can get to that, you can link to that website through the Supreme Court's homepage. If you look up the DRB, there's a link to the archived decisions of the DRB. In your materials, I've also given you the link that you can type in to get into the DRB's decision. They have a very primitive search engine that you can utilize. So if you're researching In Re Schmo, you type that in, you'll see Schmo plus all the times that Schmo has been cited. If you're concerned about RPC 1.1a, you type in RPC 1.1a, and you'll get the phone book, but you'll get all the cases that they've discussed that particular RPC in. This is not as bad as it sounds for reasons which I'll tell you about momentarily, but this is what you've got to do because, again, the precedents that the DRB cites, they rely on their own precedents, even though there's a Supreme Court, a citation in New Jersey reports, it's meaningless. You've got to look at their opinion, okay? Very critical that you look at your client's conduct in the context of what they have done with guys similarly situated to your guy, all right? And say, listen, you have these 5 precedents, these guys got reprimands, my guy should get a reprimand too. Or, in these 3 cases, my guy, these guys only got 3-month suspensions, my guy should only get a censure because he has these additional mitigating factors. You use this for purposes of advocacy, but you've got to cite what the court has done in the past so there's consistency and a lack of chaos, predictability basically. Next, very important, what is your guy's prior history? It makes a big difference if your guy's been practicing 35 years and this is his first trip to the Supreme Court for disciplinary purposes. By definition, if it's the first time he's been in trouble in 35 years, it's aberrational conduct. And you say, listen, this came about as a result of circumstances unlikely to recur. He'll probably go another 35 years before you catch him again. And then you could point to other factors, depression, alcoholism, death of a spouse, some kind of other sickness, something to indicate that this is just something that's not going to happen again in the future. Then you get the other type of guy who he's there every 2 years. He's before the Supreme Court, and they keep disciplining him all the time, and it's just not getting through to him. Those are very difficult cases for you. The court utilizes the concept of progressive discipline. So each time you come through, in order to deter you from future acts of misconduct, especially the same type of thing, like lack of diligence or gross negligence or something like that, they'll keep ramping up the level of discipline, maybe starting off with a reprimand, and then when you don't get it, the next time you come through a few years later, they suspend you for 3 months. Then the next time you come through after that, they suspend you for a year. They keep kind of ramping it up. Eventually, they get to the point where they say,
"That's all I can stand. I can't stand no more."
All right, those are the disbarment cases. You read those disbarment cases over, you say, well, this has been the guy's first trip through. He probably wouldn't have been disbarred, but this is his 5th trip through, and basically there's nothing they can do to protect the public from this attorney except disbarring him. There is no other practical way to protect the public from him, okay? So you have to look at your client's prior disciplinary history in context, okay, and argue basically along the lines that I've just been telling you. Everybody has different disciplinary histories. Next, what was the extent of harm to clients, members of the public, or the administration of justice? Now, of these, the one the court is going to be mostly concerned about is harm to clients. And harm to clients can be physical harm, it could be jail. Usually it's going to be monetary, okay? Either that it cost your client a lot of money or your client lost an opportunity that he rightfully should have had because you let a statute run or didn't file an appeal or did something goofy that's going to cost your client a lot of money. Mitigation in these types of cases is what steps have you taken, either through insurance or out of your own pocket, to make your client whole. So often you can negative or mitigate the damage done to a client as a result of action that you've taken to basically mitigate those damages. In terms of public damage, things that you do that really kind of lessen the public's respect or confidence in the bar, these are much more amorphous, but yet you've got to address these types of things. Administration of justice is going to be kind of dishonest conduct with the court, contempt of court, lying to the court, filing false papers, false affidavits, that type of thing. Again, they tend to undermine the public's confidence in the integrity of the bar, so they're serious in that respect. But when weighing what's really important here, the court is always going to be mostly concerned with harm to clients. That's the main thing that they're concerned about. So keep that in the back of your mind. And finally, any issues of rehabilitation, payment of restitution, or general mitigation of discipline. This is critically important. What you've got to do is say to the court, look, my guy recognizes what he did, and he's taken the following steps to make sure that it will never happen again, or that it's highly unlikely that it will happen again. Now, every case is different, but what do you have? Psychiatric, medical, gambling addiction, depression, ADHD, alcoholism, matrimonial, whatever it is, it may be a combination of factors. How has your guy addressed it? They don't want to hear what you're going to do. They want to hear what you've done. Building a case that says what I did wrong, the RPC violation, is generally attributable to X, and I've addressed X by doing the following things, all right? It's critically important you do that. There's a little bit of an aphorism I want you to all remember. The aphorism goes like this. Start with a blank slate. If you have a lack of aggravating factors in the case, that in of itself becomes a mitigating factor. And if you have no mitigating factors, that's an aggravating factor. But that's basically the way they look at these things. So the lack of aggravating factors is a mitigating factor, and the lack of mitigating factors is an aggravating factor. If you look at the case and your guy doesn't have any mitigating factors, you better start creating them real fast. Get him into AA, counseling, psychiatric, medication, whatever it may be. Take the necessary steps to try to explain his conduct and give assurances to the DRB and the Supreme Court that this type of stuff is never going to happen again. You have to cobble together these answers in a consistent, cohesive way when you're putting together your defense. And you can't skip any of the steps here. You've got to include all of them. By the way, here's the citation, the link to the DRB's website and their search engine on the DRB decisions. I want to take a look for a couple seconds at In re Falkenstein, which should be in your materials, just to demonstrate to you how each of these 5 questions is addressed and handled in a typical disciplinary case. And by the way, this is a DRB case, but you'll see the same thing happening in the prototypical Supreme Court decision that deals with disciplinary matters. Now, the first thing, remember, is what happens, all right? You have a right to have a hearing in these cases. You can appear before the a panel, or you get a hearing before a special master in cases that are complex or involve arcane legal issues. Typically, the special masters are appointed by the New Jersey Supreme Court, and they'll make findings of fact and conclusions of law. But there are times when you're not going to want to do that. Rather, you're going to want to try to stipulate the facts. This is especially important where there's emotional testimony, there's going to be crying and yelling and screaming. You have a much better control of the outcome if you can eliminate the human factor and just get a piece of paper that says, this is what happened, this is what we agree to. You saw me cite the Witherspoon case a few moments ago, and that's a case involving an attorney who was sexually harassing, for want of a better term, a group of his clients, all right, female clients. And these were women who were really hurt by him, not physically, but psychologically hurt by him. He decided, and it was one of the key things that saved him, to enter into a stipulation with the Office of Attorney Ethics rather than take testimony from these women. Now, he did it by saying, listen, I don't want these poor women to be victimized twice, and be cross-examined publicly on what happened with them. And that resonated a little bit with the Office of Attorney Ethics, and they entered into a stipulation. What he really didn't want to have was on videotape these women telling the truth about him and yelling and crying and screaming and carrying on, because the emotional impact that would have on the court would be devastating. So for that reason, he entered into a stipulation. I think it redounded to his benefit tremendously. In this particular case, in Falkenstein, he did the same thing. He made a determination that there would not be a hearing necessary, that they were going to stipulate as to what the violations of the RPCs were and what those facts were. So you can see in the second paragraph here, the matter before us on recommendation for a reprimand filed by the District 4 Ethics Committee, based on his stipulated violations of 1.1, which is gross neglect, 1.3, lack of diligence. And by the way, parenthetically, you always see 1.1 and 1.3 charged together. You never see them separately. They're like peanut butter and jelly, okay? They're always together, because every time you're grossly negligent, that implicates your diligence. And every time you're not diligent, that implicates gross negligence for the most part. You always see them. You never see them. You never see discipline imposed for them independently. They're always together, okay? What else does this guy do? 1.4, fail to communicate. 1.16, which is when you're supposed to be breaking off your relationship with your client. What else did he do? 8.4, which is dishonesty, fraud, and deceit. Typically, that's when you lie to your client about some aspect of the case. That's an 8.4 violation. What else does this guy do? Oh, client security fund, RPC 5.5. He apparently was practicing law while he was on the ineligible list. Now, I have to tell you, that is really minor discipline. For the most part, those cases almost always result in an admonition, admonition being the lowest form of discipline that you can get in New Jersey. So that's probably what happened here. He was just practicing while ineligible, okay? So those are the stipulated things that they say he did. And watch now, the DRB goes through and repeats what the stipulated facts were, okay? Now, I'm not going to bore you with this, but apparently he was representing a company called Halo America. There was some type of litigation that went on, and it looks like from reading this over that he lost. He was supposed to file an appeal, didn't file the appeal, lied to his client that he didn't file the appeal, okay? So the client gets hurt as a result of all this. All right? So these are the RPCs that he violated as a result of this activity. He's acknowledging this is exactly what he did. There's his statement to back it up. All right? So he did all this stuff. There's a different factual basis for the practicing while suspended. And apparently he says he never got the notice because he moved, which is fine. Still guilty of it, okay? Now, he has mitigating factors he wants the DRB to consider. Remember we talked about the importance of mitigation? Take a look at what he says here. In mitigation, respondents submitted to the District Ethics Committee an undated written character statement on summary of work in addiction and some character letters. According to his character statement, he entered an inpatient drug and alcohol program on May the 5th, where he remained until June the 29th, so he's in there for a long time. He stated that he had been clean and sober for more than 18 months after his discharge from treatment. He's been very active in the recovery community. He helps people with addictions issues, much of it pro bono, and that he attends NA and AA meetings regularly. See what he's doing here? He's building a case for saying, I attribute my misconduct because I was drunk every minute of the day and night. I'm now clean and sober. I'm involved in recovery. I go to NA and AA. The likelihood of me committing this type of offense in the future is remote based on the steps that I've taken during the intervening time period to rehabilitate myself. Respondent also submitted 8 character letters. 3 were from members of the recovery community, all of whom attested to respondent's dedication to his sobriety and willingness to assist others. Another 3 were from mothers of drug-addicted children. Ooh, you can't get any better than that. Expressing their appreciation for respondents' assistance in getting children into treatment while at the same time handling their legal matters. The remaining letters were from 2 of the respondents' colleagues, both of whom referred cases to him. The attorneys complimented respondent on his professionalism and dedication. Again, circumstantial evidence raising the inference that this is something that is unlikely to recur. Again, the people who know him best still trust him with their legal affairs. The District Ethics Committee accepted the stipulation and agreed with the violations. They believe that a reprimand was a more appropriate measure of discipline rather than an admonition recommended by the presenter. I'd look at this thing, just on its facts, and I'd say to the presenter, are you high? This is nowhere near an admonition case. This is either a reprimand or a censure case. Don't be a hozzer, okay? You ask for what this case is worth. If you look at the case law, this is clearly going to be at a minimum a reprimand case, and it could be a censure case, all right? Notwithstanding everything else, this is definitely not an admonition case. I wouldn't even ask for an admonition under these facts. The presenter wants that given aggravating factor, his continuing course of dishonesty and misrepresentation to his client, as well as his drug use. The District Ethics Committee did not believe that the character statements and letters were sufficient to reduce the discipline for respondents' unethical conduct. And you know what? They're right. This is a reprimand case, okay? At oral argument, Respondents' Counsel urged us to impose an admonition. Again, don't be a hozzer. It's not realistic to get an admonition in a case like this. Pointing out that Respondents' misconduct stemmed from the representation of one client in one matter, as well as practicing while ineligible. Okay? Now, here's the takeaway from this. Remember, the DRB has to make independent de novo findings of fact, de novo findings of law before they come up with their recommendation for discipline. And they're making these determinations on the record that was done at the hearing level or through the stipulations that they've submitted. Since there was no hearing here, it was done by way of stipulation, they've got to work with that. But they've got to find there's a basis where these RPC violations are supported by clear and convincing evidence. So what does the panel say? Following de novo review of the record, we are satisfied that the DEC's findings that respondent's conduct was unethical, fully supported by clear and convincing evidence. Respondent failed to enter a written motion to reconsider or appeal for the judgment ordered against his client, despite his client's request that he do so, etc. Okay? They go on to say, and now this is the key part here. Take a look at this. This is where it's going to save you a lot of work when you're writing your brief. There remains the determination of the quantum of discipline to be imposed for his violations. We had 1.1, 1.3, remember they're like peanut butter and jelly, they're always together. 1.4, that's communication. 1.16, he didn't break off his relationship. 5.5 is practicing while ineligible, and 8.4 is lying to your client, okay? So you've got like playing, it's like playing a Texas Hold'em. You get a particular hand, and there it is. How are you going to play this hand? What is implicated by this combination of RPC violations, all right? Well, it's going to go back to the 5 questions we talked about before. Look at the analysis by the DRB here. They are going to go through now, and they're going to take a look at all the cases where these things were in play. Okay, and they're going to discuss how each of these cases came out, and you'll be able to look at these things and look at your client and say, where does my client fit into in the spectrum here? Now, be careful, because remember, many of these citations, especially the newer ones, there won't be any case in New Jersey reports. You're going to have to go back and look at the DRB decision. For example, they start off by saying, misrepresentation to a client requires the imposition of a reprimand, and they cite In re Kasdan. Now, you can tell by looking at this is a 1989 case. Kasdan this is a legitimate Supreme Court decision. If you went, you would see Kasdan, okay? That's actually a case. A reprimand may still be imposed even if the misrepresentation is accompanied by other non-serious ethical infractions, as here. And they cite In re Singer, a 2009 case. There's no such opinion as In re Singer. To see what happened here, you'd have to go look up the DRB's decision in re Singer and read that, because the Supreme Court's decision here is just going to be a disciplinary order. It's not going to have any reasoning or law or anything like that. Okay? And they have the little background here. See, misrepresented his client for a period of 4 years that he was working on the case. The attorney exhibited gross neglect and lack of diligence, failed to communicate with his client, no ethics history. Okay, now you can see the Singer case is remarkably similar to the case that's here with this Falkenstein. Okay, that guy got a reprimand. To be consistent, to have lack of chaos and predictability, this guy should be in line for the same thing, a reprimand. You're never going to find a case where this was an admonition. Next case, what did this guy do? Attorney misled client that a complaint had been filed. In addition, the attorney took no action on the client's behalf, did not inform the client about the status of the matter, etc. You guys are getting the point here that they go through and they look at every case that was similar to this guy's case. Now, here's the trick. Falkenstein was just published a few weeks ago, okay? It's a brand new case, meaning that it's going to have all the most up-to-date law in it. If you went back and started looking at In re Singer, that's not going to help you because Singer is already 6 years old at this point, 5 years old. So whatever's happened in the intervening 5 years from 2009 until 2014, you're not going to have it there. But they've done all the work for you. When you get the DRB's decision, you'll find an exhaustive list of all the case law, either through Supreme Court precedent or their own precedent, that's going to help you put together the pitch for your client. Okay? That's why it's indispensably important that you find these cases, because they do a painstaking and searching amount of research in every single case that comes before them, and you can use that to your advantage. It'll save you hours and hours and hours of research just by finding the same combination of RPC violations that your guy has that they're discussing in one of their cases. It'll give you all the precedents you're going to need. And you can see they just do this page after page after page, relating all these people who wound up getting reprimands for similar conduct in the past. The allegations here of practicing law while ineligible, remember I told you before, these are admonition cases, so there's not going to be any citations to anything in New Jersey reports because admonitions are not reportable discipline. You don't start seeing reports of discipline in New Jersey reports until you're talking about reprimand level and higher. Things that are below reprimand, which is normally going to be an admonition, they don't get reported anywhere. There'll be DRB decisions on them and recommendations for the admonition, and you can see them all here, but they don't have any citations to New Jersey reports. But here they're talking about all the cases where people were practicing law while ineligible without more, and you can see here, without more, generally those are admonition type cases, okay? And then they cite, you know, half a dozen of them or more. Now, mitigating factors. Again, they're buying into the mitigating factors, but look at their analysis. There are mitigating factors for us to consider. By entering into the stipulation, respondent readily acknowledged his wrongdoing. Now, this is important. If your guy's going to enter into a stipulation and he's going to acknowledge his wrongdoing, that's a mitigating factor that you should be putting forward in your brief. And you cite back to In re Falkenstein, okay? My client readily admitted his wrongdoing by way of stipulation. And then you put in re Falkenstein. That's a mitigating factor. Why? Because they just said so. Respondent readily acknowledged his wrongdoing. Although he only has a 9-year legal career, the absence of disciplinary history seems to indicate that his conduct was aberrational. That's a real stretch here. I mean, 9 years is not a long time at all to demonstrate a track record. But if your guy's been practicing law for 9 years or 10 years, you're going to want to cite Falkenstein as precedent that that's a mitigating factor in your guy's case if your guy doesn't have any prior disciplinary history, okay? Again, you'll cite Falkenstein. Falkenstein doesn't have a citation to New Jersey reports yet. It's too new, but it will by the end of next month, and you'll be able to cite that for that proposition. And he has provided significant assistance, much of it pro bono, to others with addiction issues. Again, they're finding this is a mitigating factor. If your guy has done that, cite Falkenstein as precedent for that being recognized as a significant mitigating factor. On balance, we determined that reprimand is sufficient discipline for the respondent's infractions, okay? Do you see how these 5 questions we've been talking about get weaved through the analysis of the DRB when they're talking about this stuff? Very, very important that you do exactly the same thing. You see what the precedents are, and then you kind of put your guy into the niche of where they are. Now, sometimes they don't fit very neatly. You've got to argue by analogy, or you're going to say my guy has additional mitigating factors that militate toward either the same or a lower form of discipline, or if it militates toward more discipline, you got to argue why that should not be, okay? But you have to do it in the context of the case law. You just can't do it in a vacuum, all right? And these DRB decisions are really valuable in kind of building your case that way. All right. And there's the order. This is the only thing that's going to appear in New Jersey reports is the disciplinary order, which the Supreme Court has appended on the end. Again, what happened here is the DRB passed this on to the Supreme Court. The Supreme Court agreed, and they ordered a discipline for this attorney. Now, I just want to conclude this morning by talking about a couple of administrative issues. So just so you'll know the kind of the lay of the land, so to speak. There are 18 district ethics committees throughout the state of New Jersey, and they do the lion's share of the, I don't want to call it grunt work because it's really important work, but it's just detailed work that has to be done. Each committee has a secretary who has tremendously broad powers to screen inquiries and grievances that come in for merit. Many times they allege very significant misconduct by attorneys, but also fairly frequently the people are either crazy or, by the way, just as a matter of curiosity, did anybody in this room ever have a crazy client?
Here's Johnny.
No, I didn't. Okay. I'm just checking. There's people who are insane and they'll make all kinds of complaints against you, you know, or they'll allege the truth, you know, they'll say you did X, Y, Z, but what you did has nothing to do with the RPCs, okay? Or sometimes it'll be fee issues, the fee was unreasonable, or you didn't do any work, or you didn't deserve that much money, or whatever it may be. That's not an RPC violation. What the secretary will do then is, you know, kind of defer it or send it over to the fee arbitration people, and that is the forum where you contest those types of issues. Typically, the secretary will make an initial evaluation if it appears that there's some merit to it. They'll ask for your side of the story and then do an initial evaluation of it. If it appears that there's at least probable cause to suggest that some misconduct, some violation of the RPCs has occurred, they'll docket the grievance, and the kind of the system starts moving ahead with you having to give a little bit more detailed information about what happened and explain your side of the story. Please be mindful that up through and including the grievance stage, everything is supposed to be confidential. This is to preserve the reputation of attorneys from unfounded allegations of unethical behavior. It isn't until things go to the formal complaint stage, where there's an actual complaint filed, that the whole system becomes public. And once it's public, all bets are off. I mean, the newspapers can show up, all your enemies can be there, you know. People, the TV can be there, the radio can be there, everybody can be there to watch it. It's all, the whole system is public at that point. Prior to that, though, in order to protect the reputations of everybody, the system is supposed to be confidential, all right? Now, the District Ethics Committee, as I said, once the matter goes to complaint stage, will conduct fact-finding. You can either stipulate, as we saw in the Falkenstein case, or have a hearing. Normally, the hearing will be held before a three-person panel, 2 attorneys and 1 layperson, all of whom are employed by the volunteers, basically, for the District Ethics Committee. In cases involving complex, arcane issues, the Supreme Court will appoint a special master to be the fact finder. And, you know, my sense is, in the cases I've done, you get a much higher quality of justice in a complex case with a special master, because typically they'll pick somebody who has experience dealing with the issues that are before you. So there's nothing to be afraid of when you have a special master. These are people who are retired Superior Court judges and sometimes attorneys with special expertise in estates, trusts, real estate, whatever it may be, okay? So the District Ethics Committees basically will screen, docket them when there's evidence suggested, conduct the hearings, make findings of fact, conclusions of law, and recommendations for discipline, which they then pass up to the Disciplinary Review Board for review in Trenton. The Office of Attorney Ethics was founded by the Supreme Court by order of the Chief Justice in 1984. He was able to do this without getting the legislature involved because no taxpayer funds are involved in the operations of the Office of Attorney Ethics. It's completely funded by contributions from New Jersey attorneys, so we all pay for the operations of the office. The office is modeled on the same administrative plane as the Attorney General of New Jersey. So constitutionally, the Attorney General is the chief law enforcement officer of our state and has supervisory authority over the 21 county prosecutors. The director of the Office of Attorney Ethics has supervisory administrative authority over the 18 district ethics committees, but they also conduct their own investigations. Typically, the investigations they utilize are For complex matters that involve there's a lot of expense and expertise, you might need forensic proofs to go in and prove the case. Many times it's cross-jurisdictional misconduct too. It might be, the clients might be in different district ethics committee offices. So important cases, complex cases, all of those things get handled ab initio by the Office of Attorney Ethics. Sometimes also in their supervisory capacity, they'll go in and take over cases that are not moving appropriately at the district level. Maybe they're dragging their feet, or they just don't have the wherewithal to properly either investigate or prosecute a particular case on the local level. They'll come in and take over those cases as well. They also run the fee arbitration process throughout the state of New Jersey. They're in charge of the random audit program, which really has an educational component more than anything else. Although, once or twice a year they'll catch somebody who's been involved with a Wilson type situation, and that has the inevitable result if the taking of the money was done knowingly. The people who are there are career prosecutors, and many times they just stay with the office forever, so they develop a tremendous amount of expertise in dealing with these types of cases, much more so than you get on the district level, where the people are doing it on a part-time basis and typically serving a voluntary term of 4 years. These are professional prosecutors that you run into at the Office of Attorney Ethics. As I mentioned to you before, the DRB, they are kind of an intermediate appellate court for the Supreme Court, but be mindful that although they don't have the authority to discipline anybody, their recommendations are followed by the Supreme Court 98.5% of the time. So you've really got to take it seriously with you and your client. You've got to say, look, the likelihood is when we go to the DRB, whatever they say, that's what's going to happen. Okay, it's extremely unusual for the Supreme Court to deviate from a recommendation of the DRB. Finally, the Supreme Court and the disciplinary authority of the court is set forth in Article 6, Section 3, Paragraph 3. Two sentences here are very important in the disciplinary context. The second one, the Supreme Court shall have jurisdiction over the admission to practice and the discipline of persons admitted. So it is only the Supreme Court of New Jersey that has the authority to discipline anybody in our state. And by that I mean that the Office of Attorney Ethics can't discipline anybody, the District Ethics Committee can't discipline anybody, the DRB can't discipline anybody. All discipline can and must come only from the New Jersey Supreme Court as a result of this grant of constitutional authority. It's interesting here because there's nothing in the state constitution about the ability of the Supreme Court to discipline judges. This actually was reserved by the court through the case law. There's a case in 1961 where the court said implicit in this grant of authority in our state constitution of 1947 is our ability to discipline the judiciary, members of the judiciary. And by that I mean the three divisions of the Superior Court, the inferior courts, which would be tax court and municipal court, county surrogates, which are also judicial officers for purposes of discipline. Interestingly, there's nothing and there's no case law on this at all, about the ability of the Supreme Court to discipline other members of the Supreme Court. And 3 or 4 times in our history, 3 that I can think of, it's come up where a justice ran afoul of the New Jersey Code of Judicial Conduct and was subject to discipline. The justices always just submit to the jurisdiction of the court and the ability of their fellow justices to pass judgment on them. No one has ever challenged it at this point. And I think it's because the justices who are involved really want to kind of get it over with, get it behind them, take their discipline and move on. So that's what happened. I know that one of the striking ones, 1990, discipline of Associate Justice, the late Robert Clifford, for a drunk driving accident, or actually it wasn't even an accident, just a motor vehicle stop that he had in Princeton. I think Chief Justice Willentz also was disciplined for, I don't know, he was living in New York or something like that. But it's just an extremely unusual situation, but it does come up every once in a while. Now, the first sentence here is also significant. Supreme Court shall make rules governing the administration of all the courts. And the rule that's relevant for attorney discipline is set forth in Rule 1:20, okay? All of the rules associated with discipline are set forth in 1:20. I think it's 1:20-1 through 1:20- I don't know, 73 or something like that. I mean, but they're all in Rule 1:20. So if you have a disciplinary case, you want to go where the rules are, they're all right there, okay? You don't have to look anyplace else. And subject to the law of the practice and procedure in such courts. That is the grant of authority that allowed the Supreme Court to take the rules of professional responsibility, the RPCs, and impose them on us as New Jersey attorneys. The RPCs are promulgated yearly, basically, by the ABA in Chicago. It is national law in the sense that the numbers of the RPCs are the same no matter where you go in the United States. Double A, where was that stupid case we were watching on TV the other day? Kansas. We're watching an argument before the Supreme Court of Kansas. It's a disbarment case. And the presenter's up there and he's citing all these RPCs. It's exactly the same as in New Jersey. I mean, if I felt right at home. The guy's being disbarred because he blew some type of death penalty case. I think he was happy when his guy got the death penalty. He waved goodbye to him as he was being led away. But he showed up for his disbarment hearing dressed as Thomas Jefferson, okay? And you don't see it right away, but the camera pulls back. You see this guy dressed as Thomas Jefferson. He's got the wig on and the pants and the buckle shoes and all that. I'm thinking to myself, I don't think this guy's particularly serious about practicing law anymore,
Another thing, I am incompetent.
To that extent, it's kind of like the rules of evidence in New Jersey, the NJRE, same numbering system as they have throughout the whole country, again, for uniformity purposes. The RPCs, same everywhere in the United States, okay? And this is the grant of authority that imposes the RPCs on us. Two quick court rules. The main one I want you to know about is Rule 1:14, okay? 1:14 is the court rule that mandates that we as attorneys must comport our conduct to the RPCs, okay? It's a rule of court. So you see here really kind of an interplay between the state constitution, the rulemaking authority, and the practice and procedure, and then Rule 1:14 taking the RPCs and mandating that we comport our conduct to the requirements of the RPCs. That is the actual statute that requires us to do that as attorneys, okay?